Okay, good afternoon, everyone. I'm Eleanor Fox from New York University and NCA. First of all, thanks very much to the CMA, to Sarah and your wonderful team for this beautiful meeting. And thanks to the Unilateral Conduct Working Group, which is doing a very good job and being a very hardworking working group. It's my pleasure to moderate this hour and with this wonderful panel. I think you know them, but I'm going to just mention them and their authorities very briefly, and then I will tell you our plan for the hour. So to my left, of course, doing double duty right back to back is Cani Fernandez, who is president of the Spanish Competition Authority. Then we have Hakan Bilir, who is vice president of the Turkish Competition Authority and professor of finance. To his left is Marie Östman, who is director general of the Swedish Competition Authority as of January. And to her left is Reiko Aoki, who is commissioner of the Japan Fair Trade Competition and a professor including the faculty of Auckland. So this wonderful group is going to be talking about some of the challenges on unilateral conduct. You've heard some of the challenges already today, and we'll build on the program earlier today. I'll just say a word about unilateral conduct enforcement, and then I'm going to ask each of the panelists to talk for about 5 minutes on the particular challenges they see in their own authorities. Then we will have a discussion period, for which we have one and hopefully, if we have time, 2 slides to ask you your opinion. So a word about unilateral conduct. As I've been talking to the panelists and reflecting, unilateral conduct enforcement has taken a more prominent place in the scheme of enforcement across the kinds of antitrust cases that are brought within the last 10 years. It's become more prominent. There are more cases in more jurisdictions. It has taken its rightful place with mergers and cartels. This was not always so. It seems sometimes to have been a lesser area, not because of importance, I must say. For developing countries, it's always been like number one, perhaps along with cartels and mergers. Developing countries have always had and have to think of abuses of dominance because of serious monopoly problems. Certainly, changes in technology has been a huge driver. The fact of data now as the new oil and network effects, and just the technological development itself and the globalization of companies, that many of them are worldwide, and the same conduct is appearing in all jurisdictions. And perhaps through ICN, there's more interchange about what has been doing that should be in the spotlight of control over dominant company conduct. So we will talk about the challenges. There are many. I'm going to go right away to the panelists to present some thoughts and information about what is happening in their jurisdictions. And I'm going to start with Hakan Bilir. Hakan, we understand that you in Turkey have been finding more challenges than in the past, and we would like to hear a little about that and whatever else you'd like to tell us in your opening remarks. Thank you, Hasan.
Thank you very much. I want to answer these questions in terms of especially digital markets and platforms, because it's a huge part of the digital economy. We believe that in general competition law instruments are flexible and powerful to solve the problems in the traditional markets and economy, but in digital markets significantly differ from traditional markets in terms of economic structure and operational features. So it creates many challenges because typically digital markets operate under a multi-sided platform models. Economic characteristics such as network effects, economies of scale and scope, and data-driven operations can create high barrier entry. Entering digital markets often requires substantial innovations. All these features point to various structural market failures in digital markets. As we know, sectors that have natural monopoly characteristics such as electricity and telecommunication are regulated not only competition rules but also by ex-ante regulations and regulatory authorities. At this point, I would like to ask this question: is there a need for similar ex-ante regulatory rules in digital markets? As the Turkish Competition Authority, I would like to share with you the findings of our market study conducted to address these challenges. Our market study was completed over approximately 2 years. In our sector report, competitive concerns related to digital marketplace were examined under 3 main headings. These include competition between platforms, competition within platforms, and the consumer-related concerns. Our sector report recommended us the introduction of ex-ante regulation for undertakings that hold significant market power in digital markets. Our draft legislation is currently on the agenda of the Parliament. It is possible to say that our draft law is similar to European Union Digital Market Act. Although our ex-ante regulation proposals have not yet been enacted in the Parliament, we are actively and intensively applying ex-post competition rules in digital markets. Digital markets have occupied a sizable part of our workload in the last few years. We have investigated general search-related services, e-commerce platforms, real estate platforms, sport data platforms, and sports gambling platforms. Not all cases were identical in terms of challenge we faced in defining markets and showing the actual harm. 2 concrete challenges were prominent. In fact, these challenges also demonstrate why ex-ante regulations are needed. The first is that when the platform commands an almost monopolistic position and the data advantage is critical for leveraging. Timely intervention is vitally important in order not to further weaken the fringe competition in the relevant markets. This is why interim measures were used rather frequently in last few years. The second challenge has been the enormous amounts of complaints of exploitation by the commerce platforms, including excessive data collection, extensive advertisement placement, and unjustified demotion. Consequently, we think that abusive practices are now inevitably a priority with digitalization and platformization. Our main goals are improving entry conditions as well as monitoring how ecosystem-wide leveraging could be controlled. Thank you.
Thank you so much. And those are important points which we will come back to because there is a sentiment in many countries that perhaps ex-ante regulation is a needed project to fill a hole, which we will come back to. And Cani, you have told us about the diversity of your current enforcement, including both against exclusionary and exploitative restraints, and we'd like to hear what you are up to.
Thank you very much. I'm going to provide you with a summary, an overview of what is our enforcement in unilateral conducts in Spain, because in fact we were not, as Eleanor was saying, we were not as focused on unilateral for several years. And then in 2022, the board of the Council of the CNMC issued 5 decisions concerning abuses of dominant position, the same amount that had been adopted in the years 2016 to 2021. So the trend has continued. We have adopted and opened several investigations in unilateral cases, and as Eleanor was saying, those cases involve not only exclusionary abuses, but also, and mostly I would say, exploitative abuses. To mention one that is also the highest fine that we have imposed in history in our institution. In July last year, we adopted the landmark case against Booking, in which we decided that we had proved 4 abuses of dominant position, 2 of them exclusionary, 2 of them exploitative. I think we will come back to that later on. But in fact, this is proving that in many situations, and that's a reflection that I would like to convey already, given the industrial structure that we are having in Europe, and in particular in Spain, where 98% of our companies are small and medium-sized companies, in the digital sector where we are facing so many gatekeepers, the potential of exploitative abuses is high, is very high. We are not only investigating unilateral cases in the digital area, there are other areas in which we are also very active, and energy is one of them. And here I would like to convey also a learning that we have. I mean, we are not only a competition authority, we are also the regulator for energy, telecoms, media, transport, and postal. And as you were saying, in our case, we see ex-ante and ex-post regulation together. And we've discovered that, for example, ex-ante regulation in energy is not solving all the problems. And we have, as you know, the distribution networks are natural monopolies, the transmission network is a natural monopoly, and you have to have access. And sometimes there is a conflict in this access. But several times, it's not only a conflict what we witness as well a conduct as an abuse of dominant position by, for example, excluding a rival when you are the one responsible to give access to, if there is vertical integration, to give access to the network, for example. So far we have 5 cases open in the area of energy. Another area in which we are active is pharmaceuticals, and there I have to say that our cases are all exploitative. In particular, there is one of excessive pricing, the Lydian case, in which a company that obtained the classification to treat a rare disease increased the price of the package, I think, of 1 dose of the product from 900 euro to 14,000 euro without significant investments justifying it. We can come to that later, but there was a whole strategy, not only increasing the price, but before that, the strategy was also to impose exclusivity in all the producers of the substance that was going to be used in the preparation of the drug, of the medicine. So the last one that I would like to include, and it also relates to our ex-ante and ex-post activity, is in the transport sector, in particular in the railway. We've been very successful in the liberalization of the railway speed speed services for passengers. We have not been that successful in the freight transport, in the rail freight transport, where we are very much trying to solve the problem. From the regulatory point of view, it seems that we are not successful, but then we're using the competition area. because we are witnessing that the incumbent, who is, for example, the owner of most of the track services, is the one that's blocking the effective liberalization of the process. So we have several cases against the incumbent. One of the last cases is, again, a self-preferencing case, but in the real economy, because there was a bid in which freight services were, truck services, were going to be open to a bid, and then the incumbent was favoring a mother company in order to provide the services. So that's under investigation as well. So I think I'm going to leave it here, just to, because I think we are going to discuss digital afterwards, just to give you an overview of what we are doing. Yeah.
Great, thank you very much, and you've touched the big industries that have, it's not just digital, but digital always rises up, but also energy, transport, pharma appear as probably a very significant number of the dominance cases. So, Reiko, can we turn to you, because you've also told us about an increased activity of cases, as well as some regulatory reform.
Thank you, thank you. Eleanor, thank you for organizing this very interesting panel and mentioning Auckland in my affiliation. Yes, we've been executing several monopolization unilateral conduct cases. We've had 2 cases in Google, against Google, which I mentioned earlier, so I'll skip that and go on to 3 other cases that we've issued either cease or desist or cautions to. And one is about Nissin Foods, a global company that produces instant noodles, including cup noodles. And they were setting standard retail prices and promotional prices with intention of ensuring compliance with these prices. The company engaged in the following practices with retailers while instructing its partners, wholesalers, to do the same. During the regular sale price periods, Nissin informed retailers that similar pricing requests were made to other retailers and implied that promotional terms would not be provided unless the requests were accepted. Through these actions, Nissin sought to have retailers raise their standard retail prices to match the suggested price. And during promotional sales periods, Nissin made promotional terms contingent on retailers agreeing to sell at the specified promotional prices, effectively pressuring them to increase their promotional pricing to the predetermined levels. However, such practices likely violate the Anti-Monopoly Act, specifically regarding resale brightness, and as a result, on August 2024, the JFTC issued an official warning to Nissin Foods. The case underscores our concern about practice that may unjustly keep prices high during a period of rising food costs due to inflation. In another case, on July 24, the JFTC issued a cease and desist order to ASP Japan. Both ASP and its predecessor, Johnson & Johnson, had designed their end-scope washing and disinfecting machines to operate only when used with their proprietary disinfectant, Disopa, effectively forcing medical institutions to purchase this product. To prevent the use of alternative disinfectants, they introduced barcode readers to the machines and affixed 2-dimensional codes to the Disopa containers. The JFTC determined that such practices hindered market competition and caused disadvantage to medical institutions, leading to our cease and desist order. Lastly, I'll share a case involving data handling. On December 24, on December 2024, the JFTC issued a cease and desist order to MC Data Plus. The issue centered around their construction industry cloud service, which simplifies the exchange of labor safety documents and construction sites through online systems. To use the service, the customer had to register personal information about their workers, which became data that MC Data Plus prevented from exporting directly as digital files. And by the way, for construction companies, because of the regulation concerning worker safety, it's very important for them to have detailed worker data for each construction site, so that what they would like to do is to have a stock of data and then assemble them accordingly to each construction site. And they became very dependent on the data that MC Data Plus had acquired on their clouds. And this was the issue that this effectively restricted their customers from switching to competing services, discouraging competition. On top of this, the company modified its terms of service to include clauses and prohibited sharing user information with other companies. The JFTC determined that practices violate the Anti-Monopoly Act under its rules prohibiting obstruction of transactions with competitors. And these are three of the recent cases where we exercise unilateral conduct.
Thank you. So now we go on to Marie, and we were impressed by the range of activities that you were thinking about and doing, projects you are doing, from the merger angle to financial markets we didn't discuss yet, to international cooperation. So let us hear what you have to say.
Thank you. First, let me say how delighted I am to be here at my first ICN annual conference. I hope many will come. And thanks to the CMA for organizing such a great event. I wanted to make a few observations on some emerging unilateral conduct issues in the EU context that we have seen reflected in our work. Mm-hmm. And one issue that has come up is the relationship between ex post unilateral conduct enforcement and ex ante merger control. As many of you will be aware or are aware, the Tarocast judgment of the European Court of Justice confirmed that national competition authorities can apply antitrust rules to challenge certain non-notifiable acquisitions. And based on this underlying doctrine, we are currently investigating a consultation in Sweden under the abuse of dominance rules. And this case relates to media monitoring services. As far as I'm aware, this is one of the few cases so far in the EU relying on the Tarocast doctrine. And since the case is currently ongoing, I can't say too much about it at this moment, but the main takeaway is that antitrust rules can be used to address mergers that, for one reason or another, avoid scrutiny under the merger rules. I still believe that ex ante merger control is preferable to ex post analysis. It's often easier to address problems up front than to unpick them later. But in those cases where merger control rules aren't applicable, we won't hesitate to act to maintain effective competition. This is what we've been tasked to do, right? So preventing monopolization is always a priority, regardless of the size of the market. And I know there will be a separate breakout session on this theme later in the conference, which will indeed be very interesting to follow. A second issue that we have addressed in our enforcement work is the question of access to data held by dominant companies. This is a live issue in relation to digital platform markets, for example. We conducted a sector inquiry into platform markets a few years ago, and then we looked specifically at the importance of access to customer data in certain platform markets. But questions of access to data can arise in a variety of contexts, not just relating to digital platforms. So in one investigation, we looked at the conduct of an incumbent central securities depository, specifically the price and other conditions it applied for allowing other firms to access shareholder data for Swedish companies. That data is used by firms to sell analytical products in competition with the incumbent on downstream markets. We looked into suspicions of refusal to supply, margin squeeze, or unfair trading conditions. During our investigation, the dominant firm made certain changes to its access conditions and pricing, so we closed the case. But on the back of the investigation, we also advocated to government to introduce changes to the law to require that shareholder data is made available digitally, since actually right now the letter of the law could be interpreted as meaning that this shareholder data, and that is a lot of data, only needs to be offered in physical formats at the offices of the securities depository. So that's quite old-fashioned. And obviously a modernization of the law would be helpful to avoid potentially exclusionary conduct. But in the meanwhile, abuse of dominance rules have been part of the solution to keep markets open and for competition on the merits. I would also like to make an observation on the interaction between the competition rules and sectoral regulation. And this is another ever-present issue for enforcers. Some of our investigations recently have arisen out of gaps in the rapidly evolving regulatory environments in, for example, financial markets. We investigated plans by the incumbent stock exchange in Sweden to offer trade in shares that were primarily listed on arrival marketplaces, SME growth market, without asking for the issuer's consent. The intention of the incumbent were not in direct conflict with EU sector regulations, but there had been discussions as to whether there was a gap in that regulation. Our investigation showed that it was not established business practice in Europe for shares listed on SME growth markets to be admitted to trade at a second marketplace in the same geographical market. Our view was that the incumbent's conduct was not in line with the purpose of the sector regulation and could have severe exclusionary effects in conflict with competition law. So in light of all this, we issued an interim decision ordering the incumbent not to list the relevant shares unless the issuers had expressly consented to it. As a result of our decision, the incumbent aborted its listing plans, awaiting the outcome of the ongoing review of the EU regulation. And in fact, since our case, amendments have been made to EU law to close this, what we would call regulatory gap. So I would say this is an example of when competition authorities may have a role to play also in markets where there is very detailed sector regulation to close the gap. And just a final short point at this stage is that in many ways the complexity of cases has steadily increased over the recent years when it comes to unilateral conduct. But as was pointed out this morning by the first panel, it is more than ever needed to deliver fast and efficient enforcement, and it also has to be transparent and foreseeable, and that is sometimes a tricky thing, but important. So in Europe, part of this is to apply an effects-based framework in a workable manner. Hand in hand with this, we need more guidance on the EU level, and we hopefully will see new guidelines on exclusionary abuses in the course of this year, which I think will be a big help both for authorities but also for companies to provide clarity.
Yes, thank you, and thank you for bringing in so importantly the EU and what EU is doing right now with its exclusionary practice draft guidelines, which are very well advanced. I want to say a word to follow up your first point on abuse of dominance and merger control, just to mention that in the United States, one of our major cases pending in the digital area is Federal Trade Commission against Meta, which is about abusive, well, monopolization / abuse of dominance for acquiring WhatsApp and Instagram in 2012 and 2014. So it is about an alleged, and they're trying to prove the plan to acquire the companies as part of a monopoly maintenance intention. So let us go on to the remainder of our program, which will be discussion. We're going to give you a Slido, so get out your smartphones and be ready if you would like to answer the question. I'll tell you first what the question will be and a little background before I ask for the Slido to be put on the screen. You can infer from what the panelists have said some of what they think about this question. Is the unilateral conduct law of your jurisdiction, or of jurisdictions in general, fit for purpose? And so this is the abuse of dominance, Article 102 in EU, and all of the similar statutes around the world, asking whether there are gaps that cannot be easily filled by that law, and whether something else, some reform should be done, or something added. And the background is simply, as you know, I mean, they're just major issues coming out of the many litigations going on. For example, is there a new form of market power that doesn't exactly fit within the scheme that was written so many years ago? Or can the existing laws cover it relatively easily? What about proof of effects? What kind of effects have to be proved? And what burdens are existing in your jurisdiction? Is the law sufficient so that you can prove a case that I would say you think you ought to be able to prove? And many other questions, including remedies, but I won't go deeply into that because we certainly don't have time. I would like the first Slido slide, please. Is it? Oh, but I cannot. Will we be able to see what is voted? I cannot see what is voted. I would have to go over. Or you be the one that announces. What does everybody think?
Okay. So the question is, are abuse of dominance statutes fit for purpose in the digital economy? And we are going from yes 52 to no 50, moving again. So just wait a little bit until I can announce what is there at the end, because so far, yes, fit for purpose is over 50, no 47, 53 yes, 49 no, okay, 50-50, interesting.
So it's so much for predictability, which we all need.
I think it is a very tight result. I mean, it's not moving anymore. It's 51 no. No, this is changing again.
Oh.
Okay, 51 yes.
Okay.
Stop it. 51 yes, 49 no.
I'm going to take that to be 50-50, if you give it a little more time, which we can take into account now, as the panelists are now going to answer the question, and if they think it's not fit, what they think ought to be done. All right? And we're going to start with Marie. Could you tell us whether you think that your statute or EU, because we should generalize, are the unilateral conduct statutes fit for purpose, if not why, and maybe just a word about what you see as the problems that we have to work hard to make them fit for purpose.
Yes, and this is not an easy question that is answered by the audience. I think the result is very evident. But broadly, I think that the evidence shows that our abuse of dominance rules are flexible and adaptable to different types of conduct and also novel theories of harm, including in digital markets. Judgments from the EU courts confirm that. But the challenge, however, is the speed of innovation, the risk of tipping in platform markets, just to mention a few challenges, but also the comparably long time it takes to investigate increasingly complex abuse cases. So there are different ways of addressing this. One is by ensuring that competition authorities have adequate tools, including interim measures and commitment procedures, so that we can bring potentially harmful conduct to an end in a timely way, as you mentioned, Hakan. And in Sweden, we have had several positive experiences of cases involving interim measures in recent years. But there are also other ways to attack this. We could introduce ex-ante regulation of certain conduct, for example, the DMA in the EU, and we strongly support the Commission's enforcement work in this area. We can also consider new competition tools as an alternative in cases where there are structural or systematic competition issues that cannot effectively be addressed by the abuse of dominance rules. And we have seen new competition tools. They have been discussed at the EU level. They have been introduced in several EU and European countries, such as Germany, Denmark, Norway, and an inquiry in Sweden has also recently proposed giving my authority the power to decide on forward-looking competition-enhancing measures. So this is under consultation in Sweden. So the short answer would be yes, as such. Yes. They are flexible, but we need to adapt to stay relevant.
Yes, thank you. That was really interesting. And for the rest of you, I'm going to shortchange you on time on answering, so we can answer a couple of more questions. So if you don't mind, keep it now down to a minute or two. You could do short answers. And Reiko, I'm going to ask you your answer. How would you have voted and why?
Well, in case of Japan, the regulation of private monopolization does not necessarily require the formal identification of dominance. But in order to assess anti-competitive impact on the market, it is essential to first define the relevant market, evaluate the player's position within the market, and analyze the effect of the problematic conduct on competition. And these steps are complex and require meticulous effort, especially in digital markets. So it is hard to, like as the answer says, it's 50-50 in practice in Japan also. And I think our solution in case of mobile operating system is, which I forgot to mention in my opening remarks about regulation, is that instead of trying to fit the Anti-Monopoly Act, instead we did a very thorough market study on what the issues were in a very narrow market. And we we decided to introduce ex-ante regulation, Mobile Software Competition Act, which I mentioned early in the morning, to address very specific problems in the market that we were able to identify from market studies. So that's been our solution in where the application of dominance we found was going to be very time consuming.
Thank you. Cani?
Well, for me, the short answer is yes, if we use it wisely, for example, using as well interim measures or remedies, and in a timely manner. And I would say that, for example, in our case, the booking case was subject to an 18 months timeline. I mean, we have now extended that in our law to 25 months, but we have to do our investigations in 18 months. And just to give you an example of why I consider that the instruments are sufficient if applied flexibly, with flexibility. We have now 2 cases under investigation, one against Google, another one against Apple. Both of them are under Article 102 and the equivalent of our competition law. And one of them could have been also investigated under the DMA, which is a complementary tool that I think we are very happy to have. We are empowered to monitor it in Spain, so we can proceed with one or the other. But I think that we were better prepared to do it with the traditional tools. Yeah.
Right. So time is a real problem, and the cost of litigation is very high, and one cost which is actually eliminated by the DMA is when you go into court against Google, Apple, etc., you have to prove every time that they have sufficient market power, every time. And they, of course, deny it.
In that respect, I think DMA provides a very good answer.
Yes. Hakan, your answer, what would you have voted?
It is not an easy question. I think maybe it depends on cases which we handle. But in digital economy, we think that we need more powerful status ex ante regulations. We think.
Yes. Thank you. I'm going to follow up this question with another that ties in with the very first plenary this morning, and that was about industrial policy in the sense of competitiveness, in the sense of, one way of talking about it is, does the antitrust law sometimes undercut the quest to be competitive, productive, inventive? Should there be some competitiveness overlay? And so the particular follow-up question is, do you think that applications, enforcements, normal enforcements that you do of your unilateral conduct law might chill inventiveness or competitiveness? And oh, I was going to ask Reiko and Hakan, and others of you chime in if you like.
You have to be very careful, I think, about when you're going to, with this question. But I don't think that, I completely, I'm in step with the solution in the morning. What was proposed, I think the general understanding was in the morning that industrial policy and competition policy is really complementary, and that I think saying over regulation or over implementation of antitrust can chill regulation, chill innovation, is often used as an excuse. And I guess we would all say that, but I truly think so, that there's been very few, or Japan has a history of industrial policy, but what industrial policy did was to promote competition. And the firms that became really competitive were actually those firms that made it through the competition domestically. So I think saying that competition can show innovation is an excuse for not innovating.
Thank you.
Sorry, it's very personal.
You had a similar or different view?
Inventions and competitions are not counter, but complementary concept. I think mostly competition creates inventions, but because of new inventions, a firm gain much market power and market share. In that sense, competition authority must control this abusive behavior and also killer accusation, I think. Esteemed from the Schumpeter's creative destruction theory, advancing technology bring along not only opportunities but also new challenges and inequalities. If we cannot prevent those undertakings from abusing their market power, it is not possible to provide all the benefits expected from competition, including technological progress. We have to timely intervene in competition infringements that may occur in new order for paving the way for new entries and technological advancement.
Thank you. Just to put a point on it, the same question could be posed in the following way, very specifically. The big tech firms claiming you keep suing us for unilateral conduct violations and you're handicapping us, that we would otherwise be doing innovation, etc., and you're trying to hold us back. And I'm assuming from your answers, the two that were given, that you would not accept that argument. And I just wondered very quickly if Cani or Marie want to say something about it.
Yeah, I agree, and I would like also to, remind that it is the case at the CNMC, for example, that whenever we are investigating anything, we are taking into account the element of how it is going to impact in innovation. And just to bring an example from the judiciary, the Court of Justice of the European Union issued very recently a judgment in a preliminary ruling from Italy, in which the court is also analyzing whether the particular conduct at stake is chilling innovation in the first place. I mean, it was a problem of accessing to a platform, and then the platform was not providing access to a third party. And then the court says, okay, when this was designed, it was the incentive of innovation and develop it, taking into account that it would be only for the developer, or it was already there that third parties could access. So I say this because it is even the European Court of Justice including the element of impacting innovation. So I don't think we can be accused of chilling it when we are considering it in the analysis.
Yes, thank you. Now, we have only 12 and a half minutes left. I have one more Slido prepared, and I think I'm going to use it, but we really have virtually no time to discuss it, but it'll just be fun to see what you all think, and maybe 1 minute each. And this would be Cani and Marie. This is a question on excessive pricing. We have hardly spent time on it, although it has come up in some of your first presentations. And the question, may we have the slide, please, so you'll see exactly what the question is. And Cani, I'm going to ask you to be my eyes on reading the answer. And then after you see it, give your comment.
Okay, this seems to be clearer. Should competition authorities be more aggressive against excessive pricing? So far it is 65% yes, 35% no, and it's moving slightly, but doesn't seem to change it, let's say, structurally. So I would say that yes, the answer is yes.
More predictability with enforcement against excessive pricing, I know in a very narrow range. So Cani and then Marie, very quickly, what do you think is the right answer to that question and why?
Well, I think we should, but we should keep into account that these are very difficult cases, and we are not price regulators. So if there is anything that a competition authority doesn't like to, is fixed prices, because it is against our DNA. So if you have to go there, it has to be really because it is a very clear abuse of a dominant position. I mean, the test that we have in Europe already provides some guidance. Luckily, we were able to go for our excessive pricing case, with very clear circumstances. And because they have an impact, a clear impact in consumers and, probably companies that are in the chain as well. I mean, clients of or suppliers of. I think those cases, if really abusive, have to be investigated, I would say.
Great. Marie.
Yeah, when we look at our abuse cases some years back, they used to focus on exclusionary practices, but we have seen a bit of a shift towards exploitative abuses. And that is partly explained by the fact that we have had very high levels of inflation in Sweden. And that has had a huge impact on end consumers in terms of cost of living. So that also had an impact on our priorities. For example, we did a case regarding district heating, but those are difficult cases, as you say, Cani. And we also have a case concerning orphan drugs in the pharma sector in Sweden, similar to what you have described. And there, luckily, we are able to draw from others' experience. But let me also just point out that we have the impression that it's becoming more and more common for cases to have a combination of exclusionary and exploitative effects. And that could be explained by different user groups in platform markets, etc. So that is also a trend.
Thank you. So turning to our last round, our panelists will have a word or two to say on the following question. We were wondering and thinking what ICN should do next in unilateral conduct. And I'm posing it should do next, but also if you have a longer range plan, that's okay. What do you think would be a good next or ultimate next step for ICN? And I'm going to start with Reiko and then go down the line, okay? And no more than 2 minutes, we don't have more than that.
Well, thank you, Eleanor. And to say first the last word. And I haven't really have no very particular issue that the unilateral conduct topic that we could address, but in any, no matter what we address, I think it's very important for us to share the ideas, what we're doing, and opportunities to share knowledge and experience amongst ourselves is very important. And the benefit from doing so, I think, is increasing as many of the issues that we tackle and also entities that we tackle are becoming very global. So the more important that we share information. And this all means that, to me, that it's all the more important that we clearly and effectively share such valuable information so that we all make better decisions in these increasing overlapping issues. Thank you.
Yes, the ICN has a very strong catalog of work products on unilateral conduct, but a big chunk of this is quite old. It was produced 10 or 15 years ago, so one thing to do is to make sure that these projects are up to date and relevant to modern challenges, and we are about to finalize the revision to the workbook chapter on exclusive dealing. So that is one important thing to do. Just let me close by saying that when it comes to the role of the ICN at a broader perspective, I think it's important to continue to work with the fundamentals and not only to focus on new and novel issues. So keep those work products updated.
ICN must continue to attach great importance to efforts against unilateral behavior. We support the sharing of best practice and the establishment of working group among ICN members. Maybe options such as joint sector reviews or joint infringement reviews between ICN member countries can be discussed for the next step.
Thank you, Cani. And we actually have a few more minutes than I calculated, so in case you wanted to talk for more than 2, you may.
I was going to be very quick, but I mean, I think that there are 2 areas in which I think the ICN could do more. I fully agree with that. By changing what we are doing, I think that provides us with, I mean, very insightful information to proceed. But if I could ask something to the ICN, one would be, continue working with judges. This is an area in which it is very difficult for judges to understand. If they require effects, it's going to be difficult. We are going, now it seems that the world is going in a different direction. I mean, the review of the guidelines by the European Commission is going to try to make it a capability test more than effects by its approach. But maybe if we have judges that understand as well, which are, I mean, the challenges in this, maybe we are in a better position to explain to them why we have or we have not done an effect analysis, for example, depending on the case. I mean, these are cases that require economic assessment in a way or another. So work with judges to help them understand what we are. This is an area that's difficult for them. And second thing, I would like to have discussions on remedies, interim measures in particular. And not only remedies. I mean, we were using, for example, in Lydiant, the case I was referring for the pharmaceuticals, we imposed the obligation to free the exclusivity, to withdraw the exclusivity that the active substance had. I mean, Lydiant, for example, was imposing this exclusivity, so before the infringement, before the abuse, some pharmacies were able to produce the drug with magistral formulas, with this active substance. After, with the exclusivity, that was impossible. So it was not only the fine, but I guess that the most important thing to remedy the market was that remedy, I mean, to exclude the exclusivity. That's important. We have to take it into account. But I would say that even more so, interim measures, because we've been accused of using abuse of dominant cases in too long procedures. At the end of the day, when we reach the solution, it's too late and there is nothing to do. Well, remedies may be a solution, but probably the answer is closer to interim measures. And I think we should have a discussion. Which are the required standards for interim measures? Which are the results? Are there any experiences in jurisdictions? Good pieces of advice? When do not even try? When it is worthwhile doing? That would be my quest, my ask to the ICN on this.
Does any of you want to comment on the final round?
Just say that I fully agree. There are enormous challenges to explain to judges the cases that we work on during several years, and then we must explain it to judges in perhaps 2 or 3 or 4 days, and that entails challenges.
So those were excellent ideas for ICN to go forward on the unilateral conduct. It's very important sharing information, seeing where the collaborations can be made, even to bring the cases together. The companies that are global companies know the whole world markets, and they're doing strategies from the point of view of the whole world, where of course the agencies are looking from their own ground up and not seeing the whole world, and it really takes the coordination to get enough information and then to do things jointly when you can do them. And assessment of the prior work products is really important. Nothing should be let to get out of date. And the judges is a very good point. I know there was one point in time when judges were intentionally invited. I mean, that there was an intention particularly to invite judges to the ICN meetings, and it would be a good idea if more judges were invited. The idea of interim measures is actually a wonderful idea, so that it keeps the problem separate rather than scrambled eggs, which will probably never be unscrambled. And goes back to the problem of remedies. Remedies are totally important. They're as important as the liability rules, because there can be many Pyrrhic victories if the remedies are not taken. So we are getting to the last few seconds of our session, and I want to, first of all, thank the Unilateral Conduct Working Group. Thank you for your participation in our survey. Very nice to know what you were thinking on the issues. And let's have a hand for our wonderful panelists. Thank you very much.